Hello, welcome to the weekly COVID updates for employers and foreign workers. I'm going to give it a few seconds to make sure all the folks are in attendance. I want to make sure that there we go. That it's on, and giving people just a second to get started. And let me see if I can make sure that okay, good. So first, as always, we're going to recap from last week. Last week, we talked about status disruptions during COVID and how that can, whether it's an expiration of status, whether it's you're capping out on your full years, how that can really be disruptive during, the COVID travel restrictions. This week, we received a lot of questions. Like I said, every week we try to frame our questions based on the type of questions we're receiving so that it's geared towards being helpful to you all in terms of the type of information you want to receive. So we received a lot of questions on I-9 compliance and how to navigate that through COVID. So we wanted to make sure that we address that. So like I said, last week, we talked about status disruptions in the midst of COVID, extensions, grace periods, special considerations with H's and L's. And if you didn't get a chance to look at that, we went through that with great detail. Please visit our YouTube video. And if you like what you see, please subscribe. Please share this information with any of your friends. Our goal is to make sure that we give relevant key information every week, and we want to make sure we disperse that to as many people that are impacted as possible. And the only way, the best way to do that is if you share the content and if you share our webinars, so that as we're drafting these weekly webinars, if you've got friends or individuals that are impacted by all of this, we would be able to craft a seminar based on that. And if you've got any suggestions as to some things that you want us to cover, please feel free to email us at info@challalaw.com. But check out the YouTube videos for, like I said, relevant information that we'll be posting on there for all of you. We also started a new webinar series last week called Challa Chai Time, where we try to get, we talk about immigration matters and masters. So we try to get experts in the field in whatever type of specific immigration process we're talking about to give you the business side, the practical side of how to effectuate the strategies that we outline from an immigration perspective. This week on Wednesday at 11, we'll be starting our series, Immigration Stars and Strifes, to highlight extraordinary immigrants that are doing amazing things in the United States, making our country even better, and also talk about their journey. So this week, we will be talking to Liz Tyson. She's world-renowned animal activist, specifically animal captivity. So I think it's incredibly timely, because as we talk about how we are impacted by self-seclusion, the movie Tiger King, or the Netflix series Tiger King, got a lot of popularity. I mean, it was trending and everybody was watching it. And, like I said, it didn't, the irony of that I did not miss the irony of the fact that we're trying to overcome our imposed self-isolation by COVID by watching another animal taken out of its habitat and held captive. But she'll be able to shed light on her work and its impact around the world. I mean, she's actually changed legislation in the UK and has done a lot of phenomenal work, and she's currently with Born Free, and we get to hear about what Born Free is doing. So please, listen for that and sign up for that webinar this Wednesday at 11. So I-9, what is I-9? So when this came about during President Clinton, IRA, where they wanted to make sure that there was a way to ensure that that all workers are work authorized. Now, how do you navigate through that process? They put together a process called I-9. And I always say it's like walking a tightrope, because on one hand, you want to make sure that so it applies to all employees. So you know how most, there's a lot of like Family Medical Leave Act and others where it only applies if you have a certain number of employees, that compliance or that regulation is triggered. In I-9, it doesn't matter the size. So if you have any employee and your employees are all US-based employees, and whether they're US citizens or they're non-citizens, you have to I-9 every single employee in the United States. Now I said tightrope. And why did I say that? Because you have to do that in a manner that does not trigger any issues related to national origin discrimination. So we'll go through how you walk that tightrope, but it's maintaining proper employment and immigration records, and employers are to verify the identity and employment authorization without discrimination for all individuals hired. So you got to make sure that there's some consistency in the way you are undertaking this. And there's some really severe non-compliance issues that could be raised in terms of penalties and criminal violations if they deem that it's a pattern and practice. So as I said, it's used to identify the employment authorization of citizens and non-citizens alike. Employees will need to fill out a document that we will go through, an I-9 document, and then present some documents to the employer as evidence of their eligibility. And then employers must retain the documents for a period of time and make it available for inspection. I have a question. What are the steps an employer needs to complete before they lay off an H-1B employee? That's a good question. We went through that in a couple of webinars previously, but remember, H-1B employees, slightly different from a lot of other non-immigrant classifications. There's a lot of compliance, employer compliance that's involved. So when you sign off on the H-1B documentation, one of the things you're saying is that you will offer to provide return transportation to the employee, to their home country. You don't have to send them to Hawaii or any other place. You can provide them a one-way ticket to their home country. You don't need to provide it for their family members. I always tell employers that first what they should do is send in some type of mechanism where you can track and have proof that you've sent this email. So I would send the email with a delivery and a notification that it has been read. Keep those for your records. And offer the employee, say, hey, you're going to be laid off effectively this date. And, per the regulations, if you would like us to buy, you don't have to reimburse, if you'd like us to buy a one-way return transportation home to your home country, please let us know so we can make the travel arrangements. So that's one issue of compliance, return transportation home. Second is, you will have ongoing wage obligations until you withdraw the labor condition application and the H-1B petition. So you should do that as well for your employees. I hope that's clear. And if you have any other questions about what needs to be done, email us at info@challalaw.com and we can send you a memo on that. Our goal is to make sure that we equip you with the information that you need so you can make sure that you're meeting your immigration obligations. Next, this is the I-9 form. So as you can see, the form is pretty self-explanatory and straightforward. There's a portion of the form that needs to be completed by the employer and a portion of the form that needs to be completed by the employee. On the very back, they list all the documents that list A, list B, list C. And you cannot, because remember that tightrope I said? You cannot ask an employee to give you a certain document. You cannot tell them what documents you need. You can only give them that last page and they will give you the documents. So if they give you a list A document, list A documents not only provide documentation of identity, but they provide documentation of, a U.S. passport as well. And so, so that would be identity and work authorized status. If it is a list C document, list B or list C document only provide, authorization of, one provides authorization of identity and one provides authorization of work authorized status. So let me see if I can pause this. There we go. So list A document is both identity and employment authorized status. List B and C, so list B documents show identity and list C documents provide authorized status. So let's take an example. If you are a U.S. passport holder, you could show your U.S. passport. Or if you are entering the permanent resident status and you've been issued a 551 stamp as an intending immigrant in the U.S., when you enter the United States with an immigrant visa, that's a green, permanent resident visa, they stamp your passport with a 551 stamp. And that gives you, until you receive your actual permanent resident card, and that gives you, that provides the employment authorization for purposes of I-9. Now, an employment authorization document, which can be for a multitude of reasons, provides also the identity as well as your employment authorization status. Now, if you don't have that, for identity, you can use any of, the list B documents, but you have to submit a list B document and a list C document for an employment authorized status. So as you can see that Social Security, if it's not, or if it's got any restriction on it, can't be solely used. So what do most non-immigrants use? For a non-immigrant, you can use a foreign passport and Form I-94, like for H-1Bs, L-1s. That would be a list A document, with those together. And then we'll go over some of the nuances of how that needs to be annotated in just a second. So that is, what the I-9 form looks like. Now, some of the common documentation that is used is, you see that this is a visa. And the visa has listed on it the type of non-immigrant status. You don't need a visa to stay in the country. So it's not an employment authorization document. You need a visa to enter the United States. So a visa in and of itself is not going to show employment authorized status. One of the common ways in which you get employment authorized status, if you've taken a change of status or an extension of status in the US, it's with this I-797 Notice of Action form. An I-797 Notice of Action form is the form the USCIS issues when some action has been taken on a petition that you filed. Either it's a receipt notice, an approval notice. So this in particular is an approval notice for a fiancé visa. How do we know that? Up top, as you can see here, it says type of filing. So I-129F. It tells you the day it was received, the name, the type of notice, which is an approval notice, and the validity period. So that's what you receive in most I-797s. Now, in the beginning, I said a List A document was a copy of a foreign passport and the I-94 card. So previously, the I-94 card, they would issue that at the port of entry. They no longer do that. They have an electronic I-94 card that is issued. And when you are able, after you enter, you must review your I-94 card. You should review it to make sure that the CBP didn't make any mistakes. Because whatever is outlined on the I-94 card, that governs your status in the US. So you need to have a copy of that with you for work authorized purposes, showing that you are in a valid status in the United States. So you need it for other purposes, but mainly most people don't even bother to review it. And I think 2 weeks ago when we were talking about this, we actually had a participant say, oh my gosh, I just discovered that my I-94 card was incorrect. So it happens more often than you could possibly imagine. This is an employment authorization document. It's used for a number of different, it's an employment authorization document depending upon the status. So the category that's on the card, as you can see, dictates what type of status. So if you're an H4 and you've got employment authorization, that's a particular category. L2s have an employment authorization category. If you're on an F1 status and you have OPT, if you're an asylee, if you are in the adjustment of status process, all these individuals have the same card, and it's only differentiated by the category type. So that's how you would know which type of employment authorization status they have. Now, here is a copy of the permanent resident card, the green card, as everyone kind of outlines. Now, a green card has an expiration date, but that does not, it's not the same as a non-immigrant expiration date. So with your non-immigrant status, you have to, the person HR has to have a tickler in their system. So if an H-1B is going to expire on a particular date, remember those dates, they put them in the actual I-9 document. The HR is responsible for re-I-9ing them when that expires. The exception to that would be a permanent resident card. As long as it was valid at the time of the I-9, you don't need to re-I-9 permanent residents because their status doesn't expire. The card expires. That's the difference. And H-1B, their validity period is, really dictates their status in the US. So once that's expired, you have to make sure there's continued authorized status. With a permanent resident, it's the card that expires. They've done that because they want to make sure that the cards have the latest biometrics. So if the card was valid at the time you I-9 them, you don't need to re-I-9 them at the time of expiration. And so on this side, you can see that this is a stamp by the USCIS. So this stamp, what does that stamp signify? This stamp signifies a person who perhaps got an immigrant visa overseas at a consulate, and they've entered the United States either as on a family-based or employment-based or EB-5, it doesn't matter. But they've entered it on that visa, and so when they enter, They present the visa, and CBP stamps their passport with what's called a 551 stamp. Usually it's valid for 1 year, and it gives them employment authorization and the ability to travel for that 1 year. And usually they get the permanent resident card in anywhere from 4 to 6 weeks from the date of entry. So that's not an issue. So how does I-9ing change during remote work and the whole COVID pandemic? Well, first of all, there's a new Form I-9 effective May, and there's a really cool handbook that they've provided. It kind of gives you a how-to guide and some tips and how to review documentation and how to maintain records. And more importantly, it outlines the discrimination and penalties. And you know, this is what I have found. I mean, I've done I-9 audits for companies, looking through their I-9 documentation. And a lot of times everyone thinks because the form is so simple that it's not a big deal. I don't need to adhere to it so critically. No, you do. It is simple, but you know, if you don't comply with it as outlined in the regulations, you could end up being in a lot of trouble. And so I would take that simple form seriously. So during the COVID update, the DHS, Department of Homeland Security, allows employers to temporarily defer physical presence requirement for document review. What does that mean? So within 3 days, typically when an employee starts employment, it can be before they start, but no later than 3 days from when they show up at work. They not only need to complete the I-9, but remember, you're not asking them for any documents. You are only giving them the I-9 form, and they will look at page 3. And if they ask you, hey, what documents do you want me to submit? You would refer them back to that page 3 and say, I can't tell you what documents to submit, but please look at page 3. And if it's a list A document, you can say it provides both the identity and employment authorized status. If you don't have a list A document, you're going to have to give me a list B and a list C document. So part of the I-9 is completed by the employee, and part of the I-9 is completed by the employer or their designated representative. At that time, what they will do is they will look at the, not copies, but the actual documents that support identity and work authorized status. They will make a copy of that, and the employer is signing off saying that they've reviewed the documents and its authenticity. Now, in reviewing the documents, they don't expect you to be an immigration specialist. So unless, you know, for some reason on the face of it, it does not look like a correct document, you can't be an investigator and try to assume that a document that's valid on its face is incorrect, because that may put you in trouble for national origin discrimination. Here is a question: what are the possible implications to an H-1B, to the new EO that will be published in a 30-day window? And do you think it will be around new visas, or it can possibly executive order, impact extensions or transfers? Typically, most of the immigration restrictions are focused on people who are not currently holding that status in the U.S. It has the courts, the U.S. courts, because what happens is the president can sign an executive order. It's going to be challenged. I can tell you that. So depending upon where it is in the challenge, is one thing. But in reviewing how the courts have judged previous executive orders that the president has tried to institute, they usually will not impact people who are already here holding that status. It's usually those either in the future or, some other capacity. Now, like I said in our previous, webinar that, they did with, when there was a bailout for the banks, impose some restrictions on how many H-1B visa holders they had, and what the recruitment process is, and additional attestations that banks would have to undertake. It may be something like that, but it would not preclude extensions. And if it did, like I said, there would be lawsuits filed immediately. Now, I'm sorry. Let's go back. So I was saying how now that the DHS allows employers to temporarily defer the physical presence requirements. The Section 2 documents can be reviewed remotely. That means electronically. You don't have to be in place. It can only be available for fully remote workplaces. So you have to have documentation. HR must document that they have a policy that it's a fully remote workplace. And so there's no exceptions if some employees are at the work site. And then you have to provide the employees written documentation of remote onboarding and let them know that as soon as they come into the office and office is resumed, that they would have to then present those documents again in person within a three-day time frame. And the alternative option is also to designate an authorized representative. Now, I-9 always has let companies designate an authorized representative. And that could be a family member who could review the documentation on behalf of the employer and sign off on the review. So there are mechanisms in which remote employees can be I-9'd during the current COVID epidemic. But as I said, that once you're fully operational, you have to make sure that they bring the employee brings the documents to the employer within 3 business days. The employer should enter COVID-19 in the additional information field and include the physical inspection date, and also include, like I said earlier, any policy relating to how the entire workplace is now fully remote. And this is until May 19th, unless there's an extension of that remote policy. DHS issued a temporary policy for expired or expiring documentation and acknowledged the challenge of renewing List B documents typically required to complete the I-9 form, like a driver's license or a voter's registration card. So what they have outlined is they are allowing List B documents that are set from May 1st, List B documents that are set to expire on or after March 1st are acceptable for I-9 purposes for a brief period. And within 90 days after the policy ends, the employee must, present the unexpired document as a replacement. We have some questions. Let's go to the questions. Do we need to update all I-9 forms on file at our company with the newest? No, you would just need to use that new I-9 form for any forms going forward. The question is, do we need to update all I-9 forms on file at our company with the newest I-9 form version? And the question is no, it is the new form that you need to use going forward, but you don't need to re-I-9 your previous employees with the old form. Is USCIS accepting H-1B terminations and or transfers in the COVID situation? Yes, so USCIS is fully operational, so although field offices are closed, they are still processing transfers, extensions, and withdrawals. So these are the changes to the I-9 forms. And like I said, I just wanted to show you again the List A documentation, which is identity and employment authorized status. and then lists B and C, which would be for identity and then employment eligibility. As always, you know, this particular series was dedicated to just briefly going over the I-9 changes. If you have any questions, you know, feel free to email us at info@challalaw.com. If you want to review some of the issues that we went over today, you know, you can go to the Challa Law COVID-19 webinar series and go on our YouTube channel to review the information. And that's why we're putting all the information up on YouTube, so you will have a chance to kind of go over and re-listen to any information that you need, maybe a refresher on. If you like our YouTube channel, if you find our information helpful, please feel free to subscribe. If you've got a comment with some questions after you review a particular YouTube video, comment on it and we will promptly get back to you. And if you've got friends, let's make sure that people have access to relevant and accurate information during this time. Please share our information with your friends. And we've got another question. How can an employer know if an employee, how can an employee know if an employer has terminated his H-1 if not informed by the employer and not offered a one-way ticket? Well, the employer would be in violation of the H-1B regulations, and the employee would not know. And, you know, I think that would be unconscionable on two levels. I mean, if you inform the employee may be able to avail themselves of a 60-day grace period where you could still withdraw the H-1B and, you know, do the necessary things, but they would have 60 days in which they could, you know, try to find other employment. And if this COVID ends and you have a job offer, you could rehire them. But you must offer them a one-way ticket to their home country. And I'll tell you another reason, if you don't think that, perhaps worrying about the employee is top on your list because you're having all sorts of business challenges. If you're ever audited, and I have represented companies through Department of Labor audits, and they will look for documentation that you have offered a one-way ticket home to your employees. And if you can't provide proof of that, you could be sanctioned. And if a lot of times employees now know what the obligations are, and they can, report that to DOL themselves. So I would really caution against not complying with that portion of the regulations. If you have any other questions, like I said, feel free to email us. We've got tons of resources we can send you, and we'd be happy to answer any questions you have. Sign up for our social media on Twitter, Facebook, because we post on those platforms the latest information with regard to any updates we have. So you'll get the latest information as it's happening. And take a look at our other series. They may be helpful. We're going to be posting something on remote workers soon, so you'll know how that needs to be treated. And if you have a chance, sign up for our webinar next week, this week, which is on immigration, stars, and stripes. We'll be talking to an O1 extraordinary ability individual who is internationally recognized in the field of animal rights. Next Wednesday for our Challa coffee chai time, we're going to be talking about EB-5 regional centers as an option for permanent resident immigration into the United States for Fs, Hs, and the like. So, and we will have someone from a regional center come in so they can tell you about what the mechanics of that is. There is another question. And the question, we've got two questions. Is a change of status request from H1 to B2, vice versa, due to the 6-year max out generally denied by the USCIS. You know, they have stated that they are going to give a little more leeway to B2, H-1B to B2 requests, or any type of B2 requests, because of travel restrictions during COVID. So I would just put that in the documentation and you know, request the extension of status. So the other thing is they had asked, what is your advice regarding the change of status if one wants to avoid air travel during COVID-19 and stay on a B2 to wait for the PERM, the 365-day rule, to be effective? I would say it depends on how long it's going to take for that 365-day rule to be effective. Remember, you can extend your H-1B beyond the 6 years if your PERM and or I-140 has been pending for 365 days. Now, when you request a change of status from H-1B to B2, they will not give you, you can only ask for it in 6 months increments. So, you know, you may want to keep that in mind. It may be better to get on an F1 visa and join a small, maybe 1-year program while this is happening. You may have to enroll for a semester to be able to do that, but that may be a better mechanism than, you know, changing to a B2, or maybe you want to try both, you know, but there's, when you are, what they call bridging statuses, there's some real things that you need to look out for. So email us and we'll be able to tell you details about how that can be effective. What if an L1 case is denied while the resource is in 240 days and international travel is banned? Well, what I would do is, if the case was denied, and if you'd like us to review it, we're happy to review it. It's probably easier to do a refile, because I am pretty certain that they're going to open up premium processing, at least for some cases, fairly soon, because it's revenue that they're losing. Especially because travel is banned. I don't know if you all tried to get a supervisor to review the denial to see if it can get overturned, even without filing a new petition. Appeals take a long time, but even before filing an appeal, you can ask the supervisor to review the petition and see if they can apply for it on the merits. But you know, I would maybe try to file for a change of status in some capacity to perhaps a B1 while you're trying to refile the L1 case, and you know, maybe change their status to a B1 if it's still within, you know, the grace period, and cite the fact that international travel is banned now, and then concurrently try to refile the L1A and to get it approved. Because even though there's a high instance of denials with Ls, we've experienced tremendous success. So if you want to email us your L denial and have us take a look to see what the problem was or any suggestions that we may have, we'd be happy to do that. So good luck. I know it's tough in these times to deal with all these challenges in addition to the COVID. We've got some questions on the Q&A. My 60-day grace period starts from my last working day or the last day paid up to. Should be the last working day. What is your advice if there needs to be a change of status from L2 to F1, attaining age, without leaving the country during COVID? All you would need to do is file an I-539 with the USCIS. You said if you change your status to L2 to F1, already have a valid F1 visa. So you have a visa, but I'm going to assume that you're currently in the United States on your L2. If that is correct, then you would just, since you can't leave the country, which would be the quickest way to change your status, I would just file for a change of status from L2 to F1, before you reach the age of 21. Is my priority date current since 2018 on EB3 priority date? Is that I've missed the window as I've changed employers? Can I port to that priority date to a new employer? You said employee, but I'm gonna assume port the priority date to a new employer. You can port the priority date. You would have to refile the PERM and I-140, but the great news is, because you have a previous priority date, that priority date, once the I-140 was approved, so if your priority date is, the I-140 was approved, then you're going to be able to port that to the new employer. In order to file the I-485, you would have had to still not be with your employer now, but there has to be an offer of employment prospectively for that employer. Now, so if you don't want to go back to your previous employer, you can file now and you can port your priority date. I think there is one more question on chat. Let's see what that is. Is the priority, okay, that's the same question. Okay, good. So I think we have answered all questions. Like I said, if you've got any additional information or very case-specific information you'd like us to answer, please email us at info@challalaw.com. Thank you so much for signing in. Stay safe. Again, this is Lakshmi Challa signing out. I look forward to seeing you next week. Same date, same day, same time, for any new COVID updates. But in between Wednesdays, if you'd like to check out either our Challa Chai Time, where we invite experts, or this week, Immigration Stars and Stripes, where we're going to be having, folks, immigrants with exceptional ability in various areas, highlighting their pathway, highlighting their evidence, as a way in which we can change the narrative that immigration is somehow detrimental to the U.S. economy. We're trying to show through our webinar and our discussion that it actually is the foundation of what makes America so great. And then next Wednesday, we'll be talking EB5 for those of you who are looking for permanent resident options, whether on an F1 or H1B or overseas. Again, thanks again. I look forward to talking to you again. And if you found the information helpful, share it with your friends, so we can make sure that we are reaching as many people as possible and helping them navigate through this difficult time. Take care.